Hello, my name is Nishtha and I will be talking about special rule of evidence. Now, what is evidence? Evidence is used in the court to prove the veracity of the argument. For example, in a case, the state has to prove the guilt beyond the reasonable doubt, and in that case, the defendant can use the evidence to prove the case against the state. Talking about evidence, witness also plays an important role in any of the case. However, the court can also dispense with the presence of the witness in any of the case. But the court has to make sure that the necessary expenses like pleader's fee, the witness fee, or overall the court's fee has to be paid. For dispensing the presence of the witness, the court has to issue a commission. The commission is issued to ensure that the examination of witness would happen according to the provision of this code. The commission can be issued by Chief Metropolitan Magistrate or Chief Judicial Magistrate. However, if the witness is in an area where this code does not extend, then the central government, by way of a notification, can inform the court in that area to apply the provision of this code and to examine the witness accordingly. Under Section 286 of the Criminal Procedural Code, on the issuance of the commission, the Chief Judicial Magistrate or Chief Metropolitan Magistrate shall go where the witness is and take the evidence in accordance with the provision of this Act. When any commission is issued and it is executed, then that commission shall be returned to the judicial magistrate who issued it. And also, all the necessary procedure that was taken while the examination of the witness on commission shall be specified on the commission itself. Also, the return and the disposition of the commission should be open at all the reasonable time at which the parties and the court can inspect the veracity of the commission and the details that are given on the commission. Under Section 289 of the Criminal Procedural Code, if a commission is issued for the examination of witness, then the proceedings of the actual case can be halted for some time, the time which is reasonable for the examination of the witness on commission. Now, talking about Section 291 of the Criminal Procedural Code, it lays down a special provision for medical witnesses. It is applicable in the cases where the medical witnesses were not examined. However, it could also extend up to the cases where they were called, however, they were yet not examined. Now, under Section 291A of the Criminal Procedural Code, it is mentioned that if any document which is signed by executive magistrate, then that document can be used as an evidence with respect to any person or any property. However, the magistrate cannot be called upon as a witness. Criminal Procedural Code also lays down separate provision for scientific documents and scientific expert. So, under Section 293 of the CRPC, it is given that who would be considered as a scientific expert. Now, any document which was given to a scientific expert for his opinion or for his examination, that document would be valid. Moreover, also, if the court summons a scientific expert, but the expert cannot come, so thereby he appoints any of his agent who is equally competent to summon the court. However, it must be kept in mind that the agent who is sent by the scientific expert must know the facts of the case, and also he is competent enough to prove the side of the scientific expert. The provision of this code also applies on foreign witnesses and on foreign courts. However, it must be specified that those courts, the countries in which those courts practice or in which those practitioners work, the central government should, by way of a notification, have already specified those countries, and also the person who is in context must be competent enough according to the laws of that country to execute a commission of investigation and the commission of examination of a witness. Now, talking about Section 294 of the Criminal Procedural Code, it mentions that if any party files or submits any document to the court as way of an evidence, then both the parties and the pleaders of those parties would be called upon to check the veracity of those documents. Moreover, the format in which those documents need to be submitted is to be specified by the state government. Under section 295 of the Criminal Procedural Code, it is mentioned that if any application is made in the court and in those application a public servant has been criticized and there has been allegation against that public servant, the court can ask for the applicant to give the evidence for the same. Also, the applicant can be made to produce the evidence of the same. Under section 296 of the Criminal Procedural Code, it is mentioned that if the evidence that is submitted by a party and if the evidence is found to be of a formal nature, then in that case affidavit need to be submitted to the court. Moreover, the court can also summon and interrogate the party based on the facts that are mentioned in the affidavit that is given by the other party. Under section 297 of the Criminal Procedural Code, it is given that if anyone wants to sworn on the affidavit, then the affidavit must be affirmed by the judicial magistrate or by any commissioner which is appointed by the high courts or the notary which is appointed by under the Notary Act. Moreover, clear guidelines have been given in regards to affidavit. It is given that the affidavit should contain only the information which the applicant found to be true, and the applicant is also in a position to prove those facts to be true. And also he should furnish the ground for such belief that the facts that are given in the affidavit are true. Moreover, any facts that are given in the affidavit which are found to be scandalous or which are found to be untrue, then those facts are to be struck down or they could be altered. Moreover, the court has also given guidelines that if the person is not sure as to which portion of the affidavit has been sworn in and it could not be construed through personal knowledge or through any other source, then in that case that affidavit would not be treated as a legal evidence in the eyes of law. Under section 298 of the Criminal Procedural Code, it is mentioned that if a person is found that he was previously convicted of some of the offense, then in that case, what would be the leading evidence to prove the same? It could be proved by two ways. One, in which any officer who was in charge of all the documents that led to the acquittal or conviction of the accused. Moreover, all the documents or the warrant under which the convict suffered conviction, or the documents that are signed by the officer of the jail in which the person has undergone a sentence. Under section 299, guidelines are given that what would happen in case in which the evidence is recorded in the absence of the convict. So in case where the convict cannot be found, in that cases the evidence could be heard or could be recorded in the absence of the convict. In such cases, the court who is competent to hear the evidence against the convict can take all the evidence which are provided by the prosecution, hear the same on behalf of this. However, in case where the prosecution is dead or is not able to produce the evidence, and the evidence cannot be taken by the court without spending unreasonable amount of expenses or inconvenience or time, then in that cases such would be considered as unreasonable. The Criminal Procedural Code 1973 provides a broad area in which the special rule of evidence that are provided in this act are also applicable in foreign land and also in the areas where the provision of this code is not applicable, like in the tribal areas of Nagaland and so on. Also, this code is applicable on mint officers and scientific expert, on medical man, so on and so forth. So these provision laid down a very broad discretionary power, and it also laid down provision for take into account various circumstances that could take place. Thank you.